is your American dream?
So my American dream is to have a family and to just live a successful life, a life, in abundance, and to give back as well to the community and society that I live in.
My American dream at the moment is just to raise a family and be happy.
My American dream is pretty simple: peace and justice for all.
I'm from Russia. I don't live in America, but my American dream is peace around the world, peace between countries.
My American dream is that everyone has freedom of a lot of different things: freedom of speech, freedom to get wherever they're trying to accomplish in life, their dreams, their goals. Every dream that Americans have is something that's tangible and something that can be accomplished.
Everyone has a right to the American dream.
Groundhog Sam! All right, put that over there. Now that goes there. I told you, wrong place. Oh, come on. Careful, be careful. Oh, I'm going to be cleaning all day. I know it. Oh, hello, everybody. So we're doing a little construction in the office, and Brad asked me to supervise. I'm foreman Groundhog Sam to you today. Yes, I am. I'm very official. And I'm making sure that there aren't any accidents around here. Of course, I get blamed for everything because I'm the groundhog. But I told them we hope it doesn't, but if worst case happens and there is an accident, at least they're in the right place, because Bernstein handles personal injury claims as well as immigration. Yep, that's right. And now is the time that we've all been waiting for. It's time for Brad's Show Live, starring Brad Bernstein. Enjoy. All right, that's right. Yes, that's the spot. Now I've worked up an appetite. Oh, what is that? Is that spinach linguine? Maybe it's black squidding pasta. I have to go check it out.
Welcome, everybody. It is Monday, April 3rd, 2023. My name is Brad Bernstein. This is Brad Show Live. We're going to be talking immigration. I'm going to be answering your immigration questions very shortly. Our lines are already starting to heat up. But in the meantime, let me say hello to the squad. Debisha Dwyer is present. Check. Check her off. Jessica Kalimi, how are you? Squad up. Earth Angel Burt. Chetty Man Bordy, squad up. Elizabeth Francis, squad up. Velma Gale, squad up. Jamila Russell saying hi. Hi. Kalian Optimistic Sybil, squad up. Sandria and JJ White saying hello, Brad. Hello, Sandria and JJ. Willie L. Williams, squad up. How are you? Sophia Henderson, good evening. Uncle Brad, good evening to you as well, Sophia. Elizabeth Francis, squad up. Uncle Brad and your hard-working staff. On behalf of all of the hard-working staff at Spartan Bernstein and Bradshaw Live, thank you. Denver South, squad up family, Sandria and JJ White, good evening. Jessica Leamy, I've said hello to already. Karen Howard Schreiber, hi from Indianapolis. Mika Hewitt saying squad up, how are you? Lucy Osani saying hi, how are you? Joyce Henry, also squad up. Denise Corn Quirky saying hello to everybody. Sophia Henderson, hello everyone. Hello, Sophia as well. Mortalyn Laird, good evening, everyone. Good evening, Mortalyn. Velma Gale, long time. I have not watched live. Velma, you didn't miss much because I haven't been live very often lately, but we're going to be live hopefully every Monday moving forward. Trust me, you didn't miss much. And Marlene Watt-Relson. Hello, how are you? Tracy Haynes saying good evening. Camille Thomas, hi everyone, good evening. I said Elizabeth Francis. Marie Brown, good evening, Brad Squad. Hello, Marie. Spicy Crazy has a pre-schmooze question of the day. I filed the G884. I have no idea what the G884 is. I never heard of a G884, but let me finish his question and see if I could make some sense out of it. And USCIS said they cannot locate my passport that they had at the time of my interview. What do I do? Oh, the G884, I guess, is the application to return an original passport. If immigration lost it, then you got to claim it's lost and go back to your consulate, wherever country you're from, and apply for a new one with a request to replace a lost passport. Sol Gara, also with a pre-schmooze question of the day. Hello, Brad. I just have one question. Good, because I only answer one question at a time. Does my wife's green card I-45 EB3 affect because I overstayed and am in removal proceedings but file asylum? Her case is in Nebraska. Does my wife's green card adjustment, EB3, your wife's adjustment does not affect her as long as she didn't overstay and as long as she's not in removal. Everybody's their own individual person. Elizabeth Francis, squad up. Asila McPherson, squad up and team. Demba Sow, thank God my favorite show is here, and Brad is more informative than CNN. Thank you, Brad. Well, thank you, Demba Sow. Appreciate that. And Velma Gale, recognizing Groundhog Sam is still at work. Camille Thomas with a pre-schmooze question of the day. Hi, Brad. If you are undocumented, is it safe for you to go on Medicare? Medicare would be for over the age of 65. You wouldn't be qualified for it if you're undocumented. Medicaid, you would only qualify under an emergency situation. So I'm not sure how you would get Medicare or Medicaid. God forbid you have an emergency situation, would be Medicaid. Let's just say hello to a few more people. There's too many people to say hello to. We got to move on with the show. Caribbean Queen, squad up. Gnarly, squad up. And Basal Mar Ebanks saying bless. Mika Hewitt saying hello. She's here. Allison Jones, big up squad from Jamaica. Squad up Jamaica. And Jonah Seabell saying hello, everyone. Teresa Mejia, hello. Faye Blades saying hello. I can go on forever and ever. Cliff 868 saying hello as well. Kimberly Powell saying hi. Fiona Thompson, hi squad. And who else we got here? Lady Jody Joy saying squad up. Please leave your questions and comments in the comment section. Your problems, your issues, all of your questions on immigration and legal questions. I will get to it in something we call our social media check-in, where I'll try to answer as many of your questions as I can. You can call Spar & Bernstein to set up a consultation with me. That telephone number is scrolling at the bottom of the screen for the entire show, 1-800-529-5465, international 212-227-8933. And of course, coming up also, I'm going to be answering your questions live. If you call that telephone number, 1-800-529-5465, international +1 212-227-8933. But first, I think it's time to start schmoozing on some immigration news. Ready? That's not what you're supposed to see. You're supposed to see me. There we are. All right. So some immigration news. Child Status Protection Act. It's complicated, but listen up. A recent policy change on March 2nd resulting from litigation will benefit many children who would otherwise be aging out of their parents' green card applications. The Child Status Protection Act, CSPA, provides direction on whether to count a child as a derivative of a principal applicant for a green card. For Child Status Protection Act purposes, a derivative is somebody who is under the age of 21. An individual who is 21 or older is no longer eligible to qualify for a green card concurrently with a parent and must be independently sponsored by that parent, which results in significant delays. And there was a litigation in NACA versus USCIS argued before the U.S. Court of Appeals for the Ninth Circuit. It challenged USCIS's conclusion that for purposes of Child Status Protection Act analysis, a child's age was locked in only when the underlying priority date was current under the second of its two visa bulletin charts, the final action date, which is the date in which somebody can actually get a green card. The plaintiffs in the lawsuit argued that USCIS should use the dates for filing chart. That's the dates in which you can file an adjustment of status application. That's the dates in which the National Visa Center will complete processing your case at the National Visa Center, depending on whether you're filing the adjustment or the NVC. And that typically allows a green card application to be filed earlier. Now, this change is particularly significant for individuals from countries such as China and India, but it's significant for every country because almost on every country worldwide, the dates for filing are a lot closer and come up a lot faster than final action dates. And if in the calculation for Child Status Protection Act, your child is under 21 on the more liberal date, which is the dates for filing, that child's age is locked in for life on your case and doesn't age out even if they're 24, 25, 26, 27, 28. It's a complicated formula. So you could always call me and I can calculate it live because I'm good at math, or so I say. But it's good news for a lot of children who are aging out. Under the new interpretation, minor applicants will rely on the earlier chart for purposes of locking in their status as derivatives. And last week, USCIS has codified their rules for laid-off workers on non-immigrant visas. When non-immigrant visa workers are laid off, whether you're on an H, an E, an L, an O, a P, they may not be aware of their options, and many, in some instances, wrongly assume that they have no option but to leave the country within 60 days. So when a non-immigrant worker's employment is terminated, either voluntarily or involuntarily, you get fired, you quit, whatever it may be, they can typically take one of the following actions to remain in a period of authorized stay in the United States. They can file an application for a change of non-immigrant status. They can file an application for adjustment of status, or they can be the beneficiary of a non-frivolous petition to change employers. If one of these actions previous to 2016, you had no time, you didn't even have an hour to do it once you got laid off, you became illegal, undocumented. In 2016, they changed the law to say there's a 60-day grace period, and now USCIS has codified that law and made it completely clear to everybody that anyone who gets laid off, anybody who gets fired on a non-immigrant visa has 60 days to figure it out. So as long as you file an application for a change of non-immigrant status, file an application for adjustment of status, or the beneficiary of a non-frivolous petition to change employers within the 60-day grace period, you're still in legal status. The non-immigrants period authorized stay in the United States, however, cannot exceed 60 days. So even if they lose their previous non-immigrant status, if the worker takes no action within this grace period, they and their dependents may have to depart the United States within 60 days or remain in the United States undocumented. Non-immigrant status is typically based on approved Form I-129, petition for a non-immigrant worker, or after admission, a subsequently approved Form I-539, which is the application to change non-immigrant status. Typically, a period of authorized stay includes the period when a timely filed non-frivolous petition or application requesting an extension of stay or change of status is pending with USCIS. Now, regulations have been codified, and they now permit a discretionary grace period, which allows workers in E's, H's, L's, O's, TN status to be considered as having maintained status in that same classification after they have been fired, after they have quit, for up to 60 consecutive calendar days or until the end of the authorized non-immigrant validity period. The 60-day grace period is important. Before a regulatory change in 2016, there was no grace period, as I said, for a terminated non-immigrant worker. If you lost your job, you had to leave immediately. The maximum 60-day grace period provides time for non-immigrant workers to maintain their non-immigrant status. Alternatively, the 60-day grace period provides time for the worker to request a change of status, which allows the worker to continue their job search from within the United States. It also provides time for certain spouses of non-immigrant workers to continue working if they have an authorized employment document, a work permit. Within the grace period, eligible H-1B non-immigrant workers may also begin employment again as soon as they find a new employer and that new employer files an H-1B petition, rather than waiting for that new petition to be even approved. A worker filing for employment in another classification, unfortunately, would have to begin employment only once the new petition is approved. But given the availability of premium processing, the wait for petition approval can be less than 15 days. The maximum 60-day grace period starts the day after termination of employment. USCIS will determine whether the grace period applies to your case during the adjudication of a subsequent extension of stay. And the grace period may apply to voluntary and involuntary cessation of employment. Basically, you're fired or quit, doesn't matter. But working during that grace period is prohibited. You would be working undocumented. But you have that 60-day grace period where you are still an authorized stay, can't legally work until you find a new sponsor, but then you can extend your stay. So typically, somebody gets fired, you're now given 60 days to find a new employer to file a new application. And on March 28th, USCIS announced it has completed the annual H-1B selection process, which is the lottery, the H-1B lottery for fiscal year 2024, with early reports indicating a record number of registrations submitted. Each year it becomes increasingly difficult to obtain one of the 85,000 H-1B visas allotted under the congressionally mandated quota, or known as the cap. In light of the news, employers and foreign national employees are now reviewing their contingency plans for those whose registrations were not selected. Employers must understand the duration and limitations of their employees' current visa status and evaluate potential opportunities to retain these talented individuals. For instance, some employees may be able to remain in the United States on their current visa to retry the H-1B lottery next year. Others may be eligible to change to another limited type of visa, such as a TN, an E, an O, an E1, an E2, or an E3, an O1, or possibly an L1, if they can meet the specific eligibility requirements for those categories. Others may be able to remain in the United States and even apply for employment authorization through a dependent visa of a spouse. While the limit on H-1B visas is meant to protect U.S. workers, the unanticipated consequence is work leaving the United States. When companies are unable to hire enough skilled workers in the United States, they will offshore these workers. They will relocate these workers abroad, giving countries such as India, China, and even Canada a competitive advantage over the United States because their tech workers and skilled workers are working outside of the U.S. And when companies offshore work abroad, in addition to decreasing the number of foreign nationals working in the United States, they may also find negative unintended outcomes. For instance, if certain processes are no longer handled in the U.S., companies may be required to reduce their number of U.S. workers as well. The effect of lost foreign national workers also negatively affects the U.S. economy as consumers, income, taxes all disappear. And a recent study by Professor Rebecca Diamond of Stanford and her colleagues at Stanford and Stanford Graduate School of Business, Harvard Business School, and the University of California, Berkeley's Haas School of Business directly measured the output of patents from foreign-born inventors living in the United States. Their conclusion? No surprise. The average immigrant is substantially more productive than the average U.S.-born inventor. The researchers started with an understanding of how Social Security numbers work. Their first numbers contain the first year of their birth. In their database, they identified 300 million adults who had lived in the country between 1990 and 2016, and then used Social Security numbers to identify those who had immigrated after the age 19. Using names and address history, the researchers matched individuals in their database to those listed as inventors with the United States Patent and Trademark Office. Their findings show that immigrants generate patents across a broad swath of sectors, including computers, electronics, chemicals, and medicine. They also discovered that while all inventors reach peak productivity in their late 30s and early 40s, immigrants decline from that peak at a slower rate than US-born inventors over the rest of their careers. Some of the trend can be explained by self-selection, since the type of people who would likely migrate to the United States on high-skilled visas are likely to be very successful. Another factor is the positive effect of diversity. Collaboration with inventors in other countries and use of foreign technologies in their patented products seems to yield productivity. Whatever the causes, the authors say the policy implication is very clear. The U.S. has done an amazing job of attracting the best and brightest immigrants. Any policy that would revamp the visa process might want to consider how big a deal immigrants are in our innovation output. And this definitely holds true for Alina Kravchenko, who we had on our show, who had appeared on Shark Tank and got a deal with Kevin O'Leary and Lori Greiner for her invention, the Swipe and Snap. And she has already created 7 inventions and 7 utility patents. We had her previously on our show. Meanwhile, U.S. Citizenship and Immigration Services has started to staff up a new virtual service center dedicated to only processing requests for humanitarian immigration relief, including visas for victims of crimes and domestic violence. In an exclusive interview, USCIS Director Jadoo described the additional service center as an important milestone and part of the agency's effort to reduce wait times for visas and other benefits. It will be the agency's 6th service center and first all-virtual service center. Everybody working at this service center will be working from home. Jadoo said, "One of my biggest visions for USCIS is to ensure that the backlog, this unprecedented backlog, is something that by the time I depart the agency is well on its way to recovery. The backlog has stopped growing. It's starting to pare down. My goal is to continue that slide downward." According to USCIS, this newest service center, which is currently operating on a hybrid model, but will eventually shift to all remote work, will begin its next round of hiring on this Friday. The agency aims to have the new service center fully staffed by the end of September 2024. It adds to existing service centers in California, Nebraska, Virginia, Texas, and Vermont. Although the center is virtual, it will accept both paper and electronic applications. It will focus on processing 4 types of requests for humanitarian relief: requests for status for crime victims under the U visa program and for domestic abuse survivors under the VAWA, requests for refugees to bring over their relatives from abroad, and requests by certain undocumented immigrants to waive their unlawful presence and become permanent residents. I know firsthand VAWA cases are taking over 3 years. 601A unlawful presence waivers are taking over a year. U visas are taking 6-7 years to get approved. So this is well overdue. Jadoo said these requests were selected because of their long processing times, just like I said. Immigrant advocates said the additional service center and staff could have sweeping impacts for abuse survivors awaiting immigration relief. Leslie Orloff, director of the National Immigrant Women's Advocacy Project at American University Washington College of Law, said that faster processing will allow abuse survivors to qualify for work authorization sooner, which for many could allow them to move out of their abusers' homes. And the U.S. Justice Department is going on a hiring spree for immigration judges in hopes of easing their case backlogs as well. In its budget proposal for the fiscal year 2024 that starts on October 1st, the department is seeking $1.46 billion for the Executive Office for Immigration Review, basically immigration judges, a sub-agency within the Department of Homeland Security. Attorney General Merrick Garland said in written testimony before a Senate, it's actually not Department of Homeland Security, it's under the Justice Department, my apologies. Attorney General Merrick Garland said in the written testimony before a Senate Appropriations Subcommittee that the request represents an increase of nearly 70% in funding and will enable the agency to hire 965 new judicial staff, including 150 new immigration judges. Garland said they would be placed in areas of the highest number of cases. There are currently about 600 immigration judges in the country, more than double from just a few years ago, handling more than 2 million cases. In addition to hiring more judges for immigration courts, Garland said the Justice Department plans to expand virtual hearings at the U.S.-Mexico border as part of a backlog reduction initiative. Last year, the number of immigration removal cases topped more than 2 million people. 2 million people in removal, up from 344,000 a decade ago. 2013, 344,000 people in removal. 2022, 2023, on track for more than 2 million. Democratic Senator Jean Sheehan, chairwoman of the Appropriations Subcommittee, said it suggests that may not be the answer that we were hoping for. Sheehan said the ultimate way to ease the backlog is not more judges, it's through comprehensive immigration reform, a goal that we've been waiting for. Last comprehensive immigration reform was 86. So 3 generations, 60 years, 50 years, was 84, 04, 40 years. We're going on 3 generations now. And President Biden is proposing increased spending to strengthen border security. In his proposed 2024 budget, the president would allocate nearly $25 billion to U.S. Customs and Border Protection and Immigration and Customs Enforcement. It's a nearly $800 million increase over the 2023 enacted level. In recent months, Biden has announced new proposals to mitigate and control direct migration to the United States-Mexico border, such as a migrant sponsorship program for people coming from Venezuela, Nicaragua, Haiti, and Cuba, and a proposed policy that would limit access to asylum for migrants if they fail to apply for protections granted by another country before reaching the United States. Breaking down the proposed $25 billion budget, CBP would be able to hire an additional 350 Border Patrol agents. $535 million would be allocated for border technology. $40 million would be used to combat fentanyl trafficking. Funds necessary to hire an additional 460 processing assistants at Customs and Border Patrol, and funds for asylum processing. Biden is proposing $865 million for USCIS. The proposed funds would go to 1, processing asylum caseloads and reducing their backlog. 2, reducing the request backlog of immigration benefits, such as work permits, travel documentation, and adjustment of status backlogs. Support the Citizenship and Integration Grant Program, and improve refugee processing. And President Biden is also proposing a new $4.7 billion contingency fund to help the Department of Homeland Security respond to surges of immigrants at the U.S.-Mexico border. According to Biden's budget proposal, the fund would receive appropriations incrementally each fiscal year and above the base appropriation as encounters on the southern border reach pre-identified levels. The Department of Homeland Security would only use the funds for surge-related functions, and Biden is also finally proposing $7.3 billion to the Office of Refugee Resettlement to help rebuild the refugee resettlement infrastructure. The Biden administration has a goal of resettling 125,000 refugees in 2024. The administration has struggled to meet that goal after services were slashed under the Trump administration. And last week, we discussed legislation in the Texas Senate, which, if passed, will make undocumented entry into Texas a state crime, with first-time offenders facing a year in prison, second-time offenders facing 2, and offenders with a prior felony conviction facing life behind bars. A companion legislation to this, also in the Texas Senate, is the proposal House Bill 20. If House Bill 20 passes, Texas will field a new unit under its Department of Public Safety to track down, arrest, and deport undocumented people. Stationed at the border, the unit will be run by a chief serving at the pleasure of the governor, who will oversee a mix of locally recruited law enforcement and ordinary citizens without a felony conviction. It's the only requirement to be part of this new force is don't have a felony. These unit members will have immunity from criminal prosecution and lawsuits in pursuing their mission to arrest, detain, deter individuals crossing the border illegally, including with the use of non-deadly force. They will also use force to repel, arrest, and detain known transnational cartel operatives in the border region. Private citizens will be given arrest powers if they are trained and specifically authorized by the governor. The new unit will exist until 2030, at which point Texas lawmakers will decide on its reauthorization. Republicans have called the bill the Border Protection Unit Act. Texas Democrats have dubbed the proposal vigilante death squads. Victoria Neve Criado, the Democratic chair of Mexican American Legislative Caucus, said in a statement, "This dangerous, radical, and unconstitutional proposal, which empowers border vigilantes to hunt migrants and racially profile Latinos, is going to result in the death of many, many innocent people." By seeking to legalize state-run deportation squads, Texas Republicans have created a dilemma for their opponents: accept the existence of the new border unit until at least 2030, or risk challenging the law with a conservative Supreme Court, with 3 judges appointed by Donald Trump. The last thing Democrats want is for the Supreme Court to say this is legal. Eric Jamino, an assistant professor of criminology and justice studies at California State University, Northridge, grew up in the Rio Grande Valley, South Texas. Was also a police officer there for 8 years, and now researches the way border policing intersects border life. Said the Republicans know that this law is going to be unconstitutional, that's bound to get challenged in the courts, and that's why they're purposely doing it. If the gambit is successful, it will change the complexity of immigration enforcement on the border for the entire Southwest region. And New York City officials are going to honor immigrant women. Here in New York City on March 28th, as Women's History Month comes to a close, a council member honored immigrant women are making a difference beyond the Bronx community. Council member Marjorie Velasquez says she wanted to recognize 3 women because the contributions of immigrants are often overlooked. Dr. Camila Tapoulis, Diana Hernandez, and Rosemary Ordonez Jenkins all received proclamations for their work. Tapoulis is the executive director of the Morris Park Business Improvement District. Ordonez Jenkins runs the immigration nonprofit Garifuna Coalition. And Hernandez Cruz is a street vendor who went viral in 2021 when a fruit stand was shut down by city workers. Other women trailblazers spoke at the event, including Letitia James, the first Black woman to be elected Attorney General in the state of New York, and Darcel Clark, who was the first Black woman to serve as the Bronx District Attorney. The honorees said women are often the invisible forces that keep families, households, and communities together. Velasquez said she hoped highlighting the women inspires the next generation of young women. And that, folks, is our schmooze for the day. I do want to remind everybody that I'm going to be answering your immigration questions in about 2.5 minutes. But in her own words, I wanted to introduce to you Sarah and Joseph. Sarah felt like her immigration issues had thrown her into the ocean before she found Sparn Bernstein. And we made sure she went from being placed in removal to becoming a United States citizen. She and her husband Joseph spoke with us outside the courthouse before her citizenship ceremony. Let's watch.
My name's Joseph.
My name's Sarah.
Thanks to the law firm of Sparn Bernstein, we are here today so that we can go through my wife's citizenship ceremony to become an American citizen.
I'm so excited. I'm from original country, Jordan. I came to America 2004. In the beginning of my process, the problem threw me in an ocean.
I knew when those letters started showing up, we needed a lawyer. When they say remove, that means we're taking you out. It affected us both deeply. My wife later on saw a commercial for the firm of Sparn Bernstein. And I said, what have we got to lose?
Bernstein, he helps me a lot. I recommended everyone. They're not a business, they are family. They care about you, they care about your case, they care about your problem. They don't leave you until when your problem solved.
4 years later, the nightmare we were going through at the time is now over.
I will recommend it, Spar Bernstein, for everybody. When I was a teenager, I have a dream, to come to United States, and this dream grow with me. And one day my mother, when she passed away, she said, "It's your dream will become truth one day." It's her spirit. I felt she's around me. I can live my dream in a great country without any interruption. A freedom to do anything you want. Like me, I got my medical license and I'm working. This is America, a great country.
All right, there we go. And we're back. All right, you ready to do meat and potatoes? Let's do it. All right. Who do we have here? Teshwana from Long Island. How are you? Teshwana. You were waiting so long. How are you?
Hi, I'm good, thanks. How about you?
Good, good. What can I do to help you today?
Well, I just have one question that I wanted to ask.
Go ahead.
Okay, so I filed a petition for my mom that was living in Jamaica like a year ago, and it is still pending. But she just recently came to the States on her visitor's visa. Is it possible I can continue her filing by filing the adjustment of status?
Yes, you can. I just want you to wait 90 days. And the reason I want you to wait 90 days is because if she comes into the United States on a visit and you file her adjustment within the first 90 days of her entry, there is a immigration rule that was codified under the Trump administration that says she committed misrepresentation. She lied when she came into the U.S. She said she was visiting, but filed an adjustment within 90 days. Nobody in the world would file an adjustment of status within 90 days after they said they were visiting unless they were lying. And then you have a problem with misrepresentation. If you file more than 90 days, there's no misrepresentation. So you would file an I-45 with a copy of the receipt notice for the I-130. You don't have to file a new I-130. And I would do it after 90 days, and your mother's going to stay here and get a green card here in the United States.
And despite I already filed the petition for her already,
Yes.
right?
Yes, correct. So you're going to take the receipt notice for that petition and submit it with the adjustment. You don't need to do a new I-130.
Okay, got you. Thank you so much.
And if you need help, you know who to call. You already called me.
I can call you and you will help me with everything.
You better believe it.
Okay, I'll save the number.
Okay, thanks.
Thank you so much.
You're welcome. Let's go to Tommy in Austin. Tommy.
Hello. Good evening, Brad.
Good evening, Tommy. How are you?
I'm good. I have a question. 2018, I got married, but I was divorced with my wife, who filed for me then, because the mother does not support our marriage. But before then, the I-130 had been approved. So they are forcing me to accept divorce, like our marriage never existed. Like they want to nullify our marriage. So I accepted, but when I meet an attorney who explained to me the consequences, then I declined.
Right.
The mother was so angry, and then you have to send her daughter to go to USCIS to tell them that I married her because of green card, because he have someone whom she already prepared to marry her daughter. He's not aware of our marriage, and her daughter told me
All
that
right.
if
So
her mom,
so you married? Where were you when you got married?
I was here in America.
And your wife was in America too, and this is a mother from another country who's meddling in on your marriage?
Yeah, we met here when I came.
Okay, so you got the I-130 approved. You got a meddling
Mhm.
mother from it. Where's the meddling mother from?
She's from here. She's here.
Oh, she's also in the US.
Yeah, she's also in
All right, so
US.
you got all right. So what ultimately happened? Did you file an abuse case?
Yes, I filed an abuse case.
What I would have done?
They did. So I filed an abuse case, but I filed it against the mother-in-law because she was the one.
No, you're still filing it against the daughter, who's your wife, who's basically the puppet of the mother.
Yeah, I never knew. So
you can't file
right
abuse
now,
against the mother-in-law. It's what the daughter, your wife, is doing as a puppet of the mother-in-law.
Yes, that's what USCIS told me. But right now, I am married.
Let me ask you a question. Did you ever divorce this woman?
Yeah, we are divorced right now. We are divorced, but
when did you get divorced?
The marriage was non-nullified, 2020.
All right, so it's too late to refile again now because you have to file within 2 years of a divorce. So what happened with the VAWA case?
I will have to withdraw it because immigration.
So then we're back to square one. You just had bad advice.
Yeah, they told me I can't file a VAWA.
What is your question now? You gave me a very sad story that you screwed up because you got bad advice from bad lawyers who didn't know how to handle a VAWA case. And it's too late now because you already did a divorce and you can't refile again because it's past 2 years. What is your question now?
Yeah,
Basically, your question is you got to start again.
I am remarried right now.
Okay.
I married in 2021.
Okay, good.
And we went for interview on December 2021. And then I have a work permit and travel parole. But we didn't hear from USCIS again until this January 2023. They call us back for another interview. And they asked me so much about what my wife told them that I married her for green card.
Okay.
I told them that was
right. Okay. So they're determining whether or not you committed marriage fraud in the first marriage. You've told me a very long story now for over close to 5 minutes. What is your question? That's what I'm here to help.
My
question
is, I have gone for second interview. What are my expectations? Like since January 10th,
is going to be one of two. Your expectation is going to be one of two things. Either one, they approve you and you get a green card and they don't find marriage fraud. Or two, you will get what's called a notice of intent to deny, which is a NOID, saying that you committed marriage fraud in your first marriage based on the evidence presented by your first wife. And as a result, you cannot get a green card through your second wife because you committed marriage fraud in the first marriage. And you're going to get this NOID, this notice of intent to deny, and they're going to give you 30 days to rebut their decision. Rebut means this is all the evidence we have. And if you don't have anything else to say, we're going to deny you, but we're going to give you the last word. Give us your last word and convince us not to deny you. That's basically what a NOID is. And you'll have to respond to it. I don't know what's going to happen next. I haven't been part of your case, but I could have seen this coming 3 years ago. Of course, this is what they were going to do. Your lawyer should have seen this coming 3 years ago. You have to wait on the NOID. If you get annoyed, not annoyed, a NOID, N-O-I-D. Don't get annoyed. Annoyed. Be smart. Be smart. Call who? Who will you call?
Yeah, call Brad.
There you are. First smart thing you've said today. All right. Well, you said a few smart things, but that's the smartest. Okay, Tommy? So just wait it out and see what happens, okay?
All right. Thank you so much.
You're welcome. All right, let's go to Gurav in Grand Rapids, Michigan. Gurav.
Hi.
Hey, how are you?
Thanks for picking up my phone. I really appreciate it, lawyer.
pleasure.
Attorney Bernstein.
My pleasure.
I have a quick question. So, I have a friend who has a conviction from October 2022. It's called disturbance of lawful meetings. It's similar to the disturbance of peace. And that person is on green card. He has to renew his green card this year by August. Can he safely apply for renewal? It's his first conviction.
Probably. This is a 10-year green card. He's renewing after 10 years.
Yeah, this is his first 10-year green card, and so yeah, he's going to renew it first time. That's correct.
And when did this conviction happen?
October 2022.
I don't know what was this in Michigan?
Yeah, Michigan.
Okay, is it a misdemeanor? I assume.
Yes, it's a misdemeanor, and the person got a conviction of a probation of 12 months with no prison time.
Okay, most likely, 99%, it's either not a crime or a crime of moral turpitude. And if it's a crime of moral turpitude, he can safely renew his green card for two reasons. One, you're not deportable with one crime of moral turpitude that occurred more than 5 years after you got your green card. And two, it's likely a petty offense and you're allowed a petty offense exception. So under both circumstances, I would say it's safe to renew your green card or his green card. Or
okay.
We're talking about.
Okay. And
this person may want to think about citizenship 5 years after the conclusion of this case.
Okay. So like 5 years after the probation ends.
Correct. Unless you're married to, or unless they're married to a U.S. citizen, then it's 3 years.
Yeah, they are married to a U.S. citizen.
Okay. So if they're married to a U.S. citizen, keep saying you, maybe it's not you. I'm sorry if I keep saying you. Could be they, could be your cousin. I don't know. But whoever it is, if you're in a bona fide marriage to a U.S. citizen, apply for your naturalization 3 years after the conclusion of the probation, and you'll become a citizen, or they'll become a citizen.
Okay, yeah, that's a great advice. And my final question is, attorney, the aggravated felony. I know that issue comes up too in these cases. Is this an aggravated felony or not?
No, because an aggravated felony, this sounds like some sort of, if anything, would be some sort of crime of violence. I can't think of any other thing it would fall under as an aggravated felony, disturbing the peace. And an aggravated felony for a crime of violence requires 1 year in jail. And you were not sentenced to 1 year in jail for a crime of violence.
Okay. Yeah, it was a suspended sentence. So
it was a suspended sentence for 1 year.
Yeah.
Okay. So that's considered a jail sentence, anything that is suspended.
Yeah.
I didn't hear the word suspended in the beginning. I think it would be smart because it was a suspended sentence. It's not a petty offense anymore because a petty offense is less than 6 months in jail. It could be, I doubt it's an aggravated felony because it doesn't sound like there's a crime of violence involved in this. But what I would suggest you do before you renew your green card is, because it was a suspended sentence and not a just 12 months probation, I would suggest that you have a consultation with me and let me actually review the actual law that was pled guilty to.
Okay, and sorry, it was, I don't know if it was suspended or not, but it said like incarceration for 12 months, but then the guy only got 12 months probation. Is that called suspended?
Probably. Let me see it for sure. Because that's a big difference between probation for 12 months and a suspended sentence for 12 months. It's a huge, huge difference. All right, hold on one second. Yeah, I can't answer. I don't know the law of Michigan. I haven't seen the disposition. So I'd have to look at the disposition, look up the law. So I can't help you more than this. Have the consultation. Let's go to Donna in New York.
Hi, Brad. Good afternoon.
Good afternoon, Donna.
Okay, Brad. I am an American citizen, and I have two nephews and a niece in Jamaica. I want to adopt and bring them up. How do I go about it?
How old are your nephews and niece?
Okay, the little boy is 10, one is 50, one is 14, and one is 15.
Where are the parents of these children?
Okay, the father is there, but he's not working. And
Where's the mother?
the mother, she can't really do very little because the father lives with his girlfriend, and as a stepmother, she don't care.
Who's
So the only
raising the
person
children? Who's raising these children?
The stepmother and the father, but he's not working.
Mm-hmm.
The mother helps when she can.
So lawyers could no longer help in these. The only way to bring children up from Jamaica is through an orphan petition.
Okay.
The orphan petition has to be filed before they're 16, but if they're brothers and sisters, it can be until 18.
Okay.
The orphan petition has to be done through an accredited adoption agency.
Okay.
They have to send social workers to your home. They do what's called a pre-adoption certificate. They took away the ability of lawyers to do orphan petitions several years ago. They just changed the rules in adoption agencies now. So it has to be done through an adoption agency. But for these children to be orphaned, they would have to leave the home of the father and the stepmother and the evil stepmother and go live in somebody else's home, have those people raise them, and then you or the people who are now raising them or a combination would go to courts in Jamaica simultaneously to you going through the orphan petition and the pre-adoption with the adoption agency in the United States. Simultaneous to that, you'd have to go to the courts in Jamaica and strip the father of his parental rights. Saying he's a father, does nothing for these kids.
Yes, right.
And then the child's an orphan. If the father signs off and says you can adopt my children, they're not orphaned. Then you would have to adopt them and go live with them in Jamaica for 2 years to bring them up, which is a difficult feat. So it's better to get the father of the parental rights and go through the adoption agency. We can help you find an adoption agency, but the actual work would be done through the adoption agency.
Okay, I'll get into it. I think I have an appointment for Wednesday with you.
Okay.
But I just want to hear what you had to say. Okay. Thank you.
All right, let's go to David in Atlanta. Hi, David. David in Atlanta. David going once. David in Atlanta going twice. I'll put David on hold. Go to Adam in Nashville. Adam.
Yep. Hello.
Hi, Adam. How are you?
It's good. How about you?
Good. What can I do to help you?
Yeah, thank you for taking my call. I have two questions. I am a green card holder, and also I'm a deported felon for aggravated felony for fraud. But my first question is, I'm paying restitution. Can immigration leave me alone until I pay my restitution?
No.
Okay. My second question is, how long will it take to get me deported?
I hope never. You never know.
Oh, that means what happens if my green card expires?
Well, maybe you're on the radar of immigration, maybe you're not. I assume you know that a fraud offense where the theft, where the loss to the victim is more than $10,000 is an aggravated felony.
Yes.
If you're an aggravated felon after February 1st, 1997, your only relief from deportation would be if your life is in danger, going back to your home country, filing a convention against torture claim, or claiming you're a U.S. citizen derivatively through your parents. Those are the only two things aggravated felons can do. If none of those two apply, I don't know when immigration is going to come. Many times they come to your probation hearings if you're going to see a probation officer. Many times they come to you.
Already see it.
Okay, many times when you go to renew your green card, many times when you're least expected, they just knock on your door. I can't tell you when they're going to come. I have no idea.
And you're saying I don't have any Chinese to win immigration case.
I just told
even
you.
if I can't get back.
I told you your two chances for all aggravated felons. One, your life is in danger if you go back home. Convention Against Torture. Someone's out to kill you.
Okay.
Two, you're a U.S. citizen because your parents were U.S. citizens and you had a green card before you were 18.
Okay.
That's it.
Thank you.
All right. Let's go to Davina in Virginia Beach, Virginia. Davina.
Hi, Brad. Good evening.
Good evening.
I have a quick question. I'm asking on behalf of a friend. So I don't know, it's a long story, but the person came to the U.S. It's been, I want to say it's maybe over 20 years now. And when they came up, I want to say it was a trip. However, it into getting
Wait, you're breaking up. You want to say they came up what on dirt? I don't know what that means.
On a visa.
On a what visa?
A visitor visa.
A visitor visa. Okay.
Yes. And then it turned into a job where they got a job and the company was trying to file for the husband and the family, right? Now, in the process, they sent for like a medical. So the medical, they would have to go back to their home country to do the medical. But because of the way that they came in, they didn't want to go back to their home country.
They go back to their home country. They're not coming back for 10 years.
Exactly. So
what kind of dumb sponsorship is this?
Yeah. So they didn't do the process. And this happened in the state of Florida. So they didn't go back. So as a result, the wife entered school. And I think you guys have a system where when you go into school for some time, the family gets the work permit, and then they get a work permit for a year, and then they push each other to school. So that has been the system over the time. So it's
I don't know what system that is. I never heard of going to school and getting a work permit.
Okay, I think when you go to school as an international, you get a work permit for a year or something like that.
You get a work permit when you graduate your program for 1 year, optional practical training.
Right. So
the family doesn't get work permits. What's the question?
Okay, so it got to a point now where the wife now got a job where they're trying to file for the family. And in the process of doing that, they are told that in between, at some point, they were considered out of status. And as a result, they got a removal letter. Is this case solvable? Like, is there something that can be done? Because pretty much
I don't have any idea because half your story doesn't make sense to me. So if they've been ordered removed, they're not going to get sponsored in a job. If they've been ordered removed, you're not going to do a job sponsorship. That's pretty ridiculous. What needs to happen is somebody needs to reopen it. Right now, there's a warrant out for their arrest, and they get deported. With an order of deportation, you don't magically get a green card. There's steps that have to happen.
I think what they got was a letter to say they're expired, like they have to leave by this time.
Stop. You're confused. You're just confusing. Because you're saying, I think this, I think that, maybe this, maybe that. Maybes. We don't solve legal problems on maybes. We solve legal problems on facts. You haven't given me all the facts, so A, I can't tell you if it's solvable or not. And two, I can tell you if there's an order of deportation, the first step before you start doing job sponsorships, you got to reopen the case. Say my rights were violated. I was ordered deported. Nobody told me. They served papers in the wrong place. So it sounds like happened to me. So that would be the first step. But we solve problems on facts, and I don't have all the facts. So hold on one second. But it's not going to be a job sponsorship, that's for sure. Hold on. All right, let's go to Junior in Washington, D.C.
Hello.
Hi, Junior.
Yeah, good evening. My question is, what's the difference with a permanent resident parents filing for their son versus a U.S. citizen parents?
How old's the son?
30.
The difference is this. A permanent resident parent filing for a son, a minor, Where's the son? Let me ask you that one last question.
The son is here in the U.S. too.
What is the son's status? Undocumented?
Yeah, undocumented. Yes, correct. Yeah.
So this is the difference. A permanent resident filing for a 3-year-old minor, that minor who is undocumented would wait about 2.5, 3.5 years for a green card, have to leave the country, go to their home country, pick up a green card, and return with a green card. The U.S. citizen filing for that same child, that child would be eligible most likely to adjust his or her status in the United States.
No, the son is 30. I said 30.
30.
Yeah, 30 years old.
Okay.
Adult.
Okay. The difference is just waiting time, which is about maybe 2 years quicker for an American citizen than for a permanent resident. But either way, it's going to be 6, 7, 8 years. Wait, do a provisional waiver, go home, and come back.
So it's about 6, 7 years wait. So while waiting, do they get like work authorization in the process?
Nothing.
Oh, so they just wait all the time.
Correct.
Oh, okay.
Yeah. But so the wait's a little quicker for a U.S. citizen than a resident, but both ways it's a long wait. All right, let's go to, I think I'm getting old because I don't hear people anymore. John in Brooklyn. John.
Hello, Uncle Brad.
John.
How are you? Yeah, I get a question regarding my. I came from Ethiopia. Can you hear me?
I hear you, but so far I haven't heard a question. All I heard is you came from Ethiopia. What's the question? I'll ask.
I came from Ethiopia, with a J1 visa, but I came from the third country, which is Norway. So due to the condition back home, after the end of the program, I applied for asylum here, and I filed I-589, and then work permit, and this is Social Security, got all those things, and I applied for expedited asylum interview in October, but I haven't heard back since then.
Why would you apply for an expedited interview based on humanitarian circumstances? What was the humanitarian?
Exactly. Because my mom was very sick, and I want her. I want to see her in the third country, or
No, you're not expediting that for that.
Yeah, I haven't heard anything from USCIS.
How long have you been waiting?
Since October.
How long have you been waiting since you filed your asylum?
I filed asylum 2022 February.
Yeah, no, they're not going to expedite it for that. February 2022, you should be getting an interview very shortly, with or without an expedite anyway. So if you filed asylum in February 22, expect an interview even without an expedite probably by the end of the summer.
Oh, okay.
But you can travel with a pending asylum. You can travel on advance parole to visit your mother.
But on this condition, like my passport from my country is expired, so I don't have any passport, so I cannot take renewal since I applied for asylum here. So in this situation, how can I travel abroad without having passport?
You can apply for a refugee travel document, and you can apply for advance parole, both of them together.
Okay, so having an advance parole will be good to travel even before the interview, while asylum is pending?
Yes.
But as a J1 visa holder, I came with certain restriction that will oblige me to go back to my home country for 2 years.
Not if you're granted asylum.
Sorry?
If you're granted asylum, that's the end of the 2-year home residence requirement.
While asylum is pending.
I just answered your question. You can get advance parole to visit your mom. Either way, you're going to get an interview probably by the end of the summer.
All right. Okay. Thanks so much.
Let's go to Sam in Sacramento, California. Sam.
Oh, hello, Mr. Brad. Good evening, sir. Yeah. Mr. Brad, I just want to confirm I traveled to Nigeria 2 weeks ago, and I have a pending condition on my green card. I came with a 2 years green card, and it's been like almost 3-4 years now that I've been scheduled for an interview. So the bottom line, I traveled last week. I just came back from there for 2 weeks, and I'm trying to go for another vacation for 4 days in Mexico. So I want to confirm. Yeah. So I want to confirm if that would not have any effect on my application.
None.
I have a stamp. I have a stamp for an extension of 1 year, which will lapse December this year.
Your trip to Mexico. Anybody with an extension on an I-751 has the same rights as somebody with a green card. You're allowed to travel in and out. Just don't stay out of the country for more than 6 months.
Okay. So I can go on multiple trips, but it should not
Absolutely.
exceed 6 months.
Absolutely.
All right. That's my question. Thank you.
You're very
You're doing
welcome.
a great job.
Appreciate it.
Thank you.
Let's go to Sidantu in Wilmington, Delaware. Sidantu. Hello, Sidantu.
Hello.
Hi, how are you?
Good. I have a quick question.
What's the question?
I come to spouse visa.
What is your question?
I come to spouse visa.
Spouse visa.
Yes.
Okay. And you have a green card, or you came as a fiance?
A marriage. I come with marriage.
Okay. Did you get a 2-year card or a 10-year card?
2 years.
Okay. What is your question?
And I applied for renewal green card in 2020, July.
Okay.
But I didn't get any reply up to now. But now me and my husband are separated. I have one kid with him, and
When did your green card expire?
in 2020.
Okay. All right. So this is what you need to do now. If
Okay.
you and your husband are separated, but you have a child, obviously it was a bona fide marriage, because nobody would pay somebody to marry them for a green card and have a child with them. That's pretty ridiculous. So if you have a child, it's presumed it's a bona fide marriage. Nobody says you have to stay in an unhappy marriage to get your green card. But if you separate from your spouse and you show up to the interview without your spouse, they're going to deny you. And if your spouse does show up to say it was a real marriage and you guys are separated, a lot of times they don't believe it anymore because you're not living together. So my advice in these situations is always, if it's a real marriage and you're separated, you're unhappy, obviously, get a divorce. Once you get a divorce, you can take your spouse off the case, because right now your spouse can write immigration anything he wants. He can say it was, withdraw the application, it was business. Who knows what he'll say? Get your spouse off the case. Get a divorce. You then convert the case to a waiver case. You can show up to the interview alone. And when you show up to the interview alone, you say, it was a real marriage back in the day. I got a baby to show for it. It's not real anymore. We were unhappy. And you would get a green card for life. And you'll be able to stay here as long as you follow the right process and the right procedures. As a matter of fact, if you file to remove the conditions in 2020, we're now in 2023. By the time you get a divorce, you will have had a conditional green card for 5 years. And I would suggest filing citizenship simultaneously.
Okay, can I apply this year's tax by myself? Because
You could only apply, your case to get your 10-year green card works if you and your husband are living together, which you're not, or you convert the case to abuse, or you convert the case to a divorce. Divorce is the most simple thing in the world, because if you are divorced and you have a baby, it's proof of a real marriage, and you're divorced, you get a green card. It's a no-brainer. And if you have, like, I don't understand, I'm confused, don't be. Just call me, have a consultation with me, I'll explain exactly what to do. So not only will you get a green card, you'll become a citizen. If you follow what I tell you to do, everything will be fine.
Okay.
All right?
Okay.
If you follow other people or start having your mind, start playing movies, you're going to screw yourself over. Hold on. Let's see if David from Atlanta is available. David.
How you doing?
How are you, David?
Good. I got married last year about 7 months ago. I filed my taxes, but I didn't have my wife do it. I did head of household. Now I'm trying to do an amendment, and I'm doing the W-7. So because it's not allowing me to do it without her social, do I just send my completed tax return in with that head of household on it, with that W-7?
No, you file an amended tax return as married, and where there's no social security, you attach a W-7 form and just and file it. Who's telling you that you can't do it?
That's what that's what tax folks I went to say.
And they don't know what the hell they're talking
about.
Go to a different tax person. Straightforward tax.
Okay.
All right?
All
Because
right.
if you submit
No
it head of
problem.
household, you're going to have a problem, especially in Atlanta. They're really hard asses in Atlanta.
And I'm telling them, and they're saying no, they did it, and they don't. You
No,
don't
they're
need to
idiots.
file it with
They're
your
idiots.
spouse.
You file married, jointly. If there's no social, attach a W-7 form, go to somebody else who knows what they're doing.
All right, no problem. Thank you.
Okay. All right, let's go to Elizabeth in Houston, Texas.
Hi, good evening. So I have a quick question about my tax.
Yeah.
And so I have my I-485 pending for interview for a very long time now, for 3 years. So my question is, can I file married separate for the income tax? Just for us to have enough money to pay back what we owed previously. And so filing married separate, will it affect my green card application that's pending?
Yes, because if you file married jointly, you're telling the government that you are both jointly responsible for the debts of the marriage. If you file married, filing separately, you're telling the government you are not responsible for the debts of the marriage. When you tell the government you're not responsible for the debts of the marriage, that will possibly alert the government to open their eyes a little more and try to figure out whether this is a bona fide marriage or not. So you solve one problem with your taxes and open up a new problem with having a problem getting your green card. I would much rather see you file a joint return and go to a tax preparer or a tax attorney who can put you on a payment plan and just pay off the taxes.
Okay, because all right, because we've always been filing jointly, and aside this tax thing, it has always been a bona fide marriage. Everything we have it together, but just this income tax.
Well,
that
Elizabeth,
bringing so much
I've given you my answer. You don't like it, do it any way you want, but don't call me back and say you got denied your green card. It'll cost you more money in the end.
Okay, all right. Thank you so much.
Let's go to also Teresa in Houston. Houston and Houston, back to back. Teresa, how are you?
Good, thank you.
Teresa.
Hi, yes.
Teresa's not listening to me. Let's go to Sammy in Queens. Sammy.
Hey, Brad, how are you?
Good. How are you, Sammy?
Good. Thank you for. First of all, thank you for your all guidance. And last week, finally, I became a citizen of the United States.
Oh, congratulations! Congratulations.
Thank you. That's all because of your guidance.
Oh, thank you.
Thank you. And I have maybe one or two questions. The first one is that when me and my ex-wife was married, and I have 4 boys back in Pakistan. So she filed for oldest one. I-130 was approved in 2000. He was under 21 that day, mine those time. And once she filed, I-130 was approved, then they sent it to the NVC. They approved, and they sent it to schedule for his interview. When he go to the interview in some of them embassy, they asked him a couple of questions because his English was not that good. So they put him in administrative processing something. then I understand they're never going to give him. So they make some excuse. Oh, you don't have a good communication with your stepmom, blah, blah, blah. So they refuse him. Now, at the same time, I filed for my 3 children for myself as a green card holder. And their case has been approved from USCIS. Then they sent it to NVC, and it's still sitting in NVC because for the pandemic, and every 60 days they send me the email. So now, what do you think? First of all,
let the NVC know you're a U.S. citizen now.
Right. So you think if I update my status, they're going to change the priority date, or it's going to stay the same?
They're not going to change the priority date, but your children are how old now?
Now, 3 of them who I did for them as a green card holder before, they are almost over 21 now.
All right.
But
they're going to upgrade to F1, which will make it go faster. And the one who's under 21 will be an immediate relative. It benefits you to let NVC know you're a U.S. citizen.
Okay. So do you think you can help me out? I can come to the office because I don't know how to update it.
Yeah. Hold on one second. Of course.
Okay. Now, what about my oldest son who get refused? Do you think I can file for him again?
Yes, and we'll talk about it. And we'll talk about it when you come in. We'll figure out what to do for him.
Okay. So please let me have an appointment.
Hold on. All right. Let's try Teresa one more time. Teresa.
Yes, can you hear me?
Yes, how are you?
Hi, good, thank you. So I've had DACA. I've had it for since 2014. Also in 2014, I was charged with an assault offense as a felony 3rd degree. Now, 2 years later, in 2016, my case was dismissed with a deferred adjudication. Now, my question is I've been married with a U.S. citizen for 2.5 years now, and I'm trying to adjust my status. But I was trying to do advanced parole, and my question is, would I have any problems with my prior charge?
You may, because there's 2 different types of deferred adjudications. There's a deferred adjudication where you do not admit guilt, where they tell you to go take a class or pay a fine, stay out of trouble for 6-9 months, and they'll dismiss the case. And in those type of situations where there's no admission of guilt, no finding of guilt by a judge, that's not a conviction. Yes, you'll be able to travel. There's other deferred adjudications where a judge says, okay, I'm going to find you guilty, or I'm going to make you say you're guilty. I'm going to tell you to go take a class on, anger management. I'm making this up. I don't know. And when you're done with the anger management class, you come back to me and I'm going to dismiss the charges against you. And although you don't have a criminal record for, life, you can say, no, I don't. But for immigration, that's a crime. Because that's a crime because you pled guilty. You were sentenced, and that's all that's required for a criminal conviction for immigration, even though the judge later on dismissed the charges.
Okay, so I did take a class.
I don't know. I would have to look at your disposition to tell you 100% certain which way it is.
Yeah, because it says I have the disposition. It says deferred adjudication of guilt terminated, defendant charged, case dismissed. Defendant completed community
your disposition won't tell me because I have to what will be on the disposition will be the section of law you were found guilty of, and then I could look up the law in your particular state and then tell you which type of deferred adjudication it is.
Okay.
All right, so hold on one second if you need help. All right, so that is our meat and potatoes. And we're going to get into our social media check-in very shortly. I do have to remind everybody that to follow us on Instagram. You can follow me personally at Real Brad Bernstein. You can follow Bradshaw Live at Bradshaw Live. You don't like to watch 2 hours of our show. You like 30 seconds, 45 seconds of Brad. Follow us at Bradshaw Live on Instagram. You can also follow us on TikTok. It's our fastest growing social media platform. And you can leave your questions in the comments on TikTok. And maybe you're lucky enough, I read your question and I give you a personal answer by video for the world to see on TikTok. You could also follow us on Twitter at Bradshaw Live, also for the best snippets from our show. Please remember to like and follow us on Facebook and subscribe on YouTube so you can be notified every time we come on live. In the meantime, I do have to remind everybody that Spar & Bernstein doesn't only handle immigration cases. We also handle personal injury claims. And in this video, I explain what you should do if you're involved in a motor vehicle accident, who will pay for your injuries, if you're involved in a motor vehicle accident in New York, and how no-fault insurance works and how it may pertain to you. Let's watch. Immediately after a motor vehicle accident, you should call the police and give your statement. Remain on the scene of the accident until the police arrive. If possible, take pictures and video of the incident with your phone. Seek medical help immediately. Every vehicle owner in New York has no-fault insurance. The no-fault insurance company will pay for medical expenses up to $50,000. If you were the operator of the vehicle or a passenger in the vehicle in which you were in will pay for the expenses. No-fault insurance covers medical expenses up to $50,000, 80% of your lost wages, in-house help if you're unable to perform routine daily activities like dressing or eating, and travel expenses to and from the doctor's appointments. New York is a no-fault state, which means that regardless of who has caused the accident, your insurance company will cover the medical expenses resulting from your injury. No fault means that regardless of who has caused the accident, your insurance company will cover the medical expenses resulting from your injury, the hospitalization, physical therapy, all within the coverage limit. It will also pay for your lost wages if you're unable to go back to work due to injuries. In New York, you can get compensation for pain and suffering only if you have sustained a serious injury. An experienced lawyer can help ensure the correct paperwork is filed so you can submit your claim on time. All right, you ready to do some social media check-in? I'm going to answer all of your immigration questions that you leave in our comments right now. All right, our first 5 questions come from our Bradshaw Live Facebook group page, our VIP page. You want to get your immigration question answered for sure on Bradshaw Live, leave your questions in our Bradshaw Live group page on Facebook. Carolyn asks, my sister is a US F1 student. She would like to apply for a green card through my parents who have green cards. Can she obtain a social security number while waiting for the I-130? The answer is no. I assume your sister's over 21 and she has a long wait ahead of her. At least 6, 7, 8 years she would have to remain in student status and then ultimately file for her adjustment. Sean Calingnago asks, I have an approved petition for F1 category January 2018. I'm waiting to submit documents online, but my 20-year-old son is a derivative on my petition. Is it USCIS policy to deal with cases in danger of aging out first before he reaches 21? Well, we talked about the Child Status Protection Act at the top of our show. Maybe he's qualified under CSPA. If he is, they're not going to expedite the case, but his age will be locked for the remainder of your case and would get a green card if he's under Child Status Protection Act. If he's not, their policy would be to try to expedite it before he turns 21. Without obviously guaranteeing that you would get the appointment. Mika Hewitt, a mother files for her daughter and the grandson has aged out. So he had to be left behind as follow to join. Now the daughter is here, got her green card and wants to file for her son. Can she do that now? And what are the steps she needs to take? File the I-130. And as soon as the I-130 is approved, there's no waiting list. So hopefully the son's still, I guess the son is aged out, so that means the son's over 21. So it'd be about 7, 8 year wait, unfortunately. That's kind of how it works. Patricia Brown, can you explain the EB3 visa and how it works, please? It's a job sponsorship visa, skilled worker. To get in that EB3 category, you got to file a perm application, get it approved, prove you're not taking a job away from an American worker, file an I-140, show that your employer can pay your salary, that you have experience in the position, and then now you're an EB3 worker. It's a lot more complicated than that, but that's the basics. Leona Brown, my husband and I file taxes together as equals. $72K mine, $20K his, but we want to do an affidavit for 4 kids. I'm not a green card holder yet. Can I be a household sponsor? Not if you don't have a green card, you cannot be a household sponsor. Sherry Raymond has a question. Oh, we're going to do a few more from the Brad Squad VIP group because I'm in a nice mood. Sherry Raymond, my husband's case has been documentarily completed at the National Visa Center for almost a year now. When would I schedule an interview? I'm Jamaican. I live in America and I'm an American citizen. You don't schedule the interview. The embassy does, and you just unfortunately would have to wait. Jessa May Elenin Olivito has a question. If I file for my illegitimate children, do I need the consent or signature of their father for the paperwork? No, not really. Teresa Mejia, I have DACA and I want to apply for advanced parole. I'm concerned about being allowed back in as I was charged with assault back in 2014. I spoke to her. She called on the show, and I said it would depend on what her conviction is. She got a deferred adjudication, but we don't know if that's a conviction for immigration purposes. If you remember, she was reading me her disposition, and I said, you need a consultation because I got to not know that I need to see the disposition to know what section of law, and then I got to read the law. All right, let's go to our social media check-in on our comments. Balacida Alamar wants to know, what are the possibilities if your case is referred to an immigration court? Well, the possibilities are you can try to adjust your status, asylum, withholding of removal, Convention Against Torture, cancellation of removal, all sorts of waivers, 212H waivers, adjustment of status. I don't know why you're in removal and what relief you're available. There's a lot available to you. That's why you need to speak to a lawyer. Let's see. Nesreen, hi, Brad. How accurate is it when I live agent on Emma's chat say that my interview was waived? I would say it's pretty accurate. Shazim Mohammed says, hello, Brad. Do you need to file separate petition or same petition for I-130 and adjustment of status for spouse and kid age 6? Please advise. If you are a U.S. citizen, you're going to file an I-130 and adjustment for your spouse and a separate I-130 and adjustment for the kid. Unless the kid's in another country, it's just going to be an I-130, but they're each getting separate applications. Danny K. Hey, Brad. My sister is currently on filing from her dad in the United States. Can she apply to do a summer internship in the U.S., being that she's on filing? She can certainly apply. Whether she'll get it or not, I don't know. Beckita. I'm not even going to try the last name. We're just going to stay with Beckita. What should I do if I ask for expedited asylum interview and could get an answer for more than 6 months? Can I travel abroad with advance parole? I think I answered that question too. I said, yes, get the advance parole. Amanda Zarella. Hello, Brad. I want to visit my dad in the UK. I have an advance parole card. Will I be expected back in the USA without a vaccine? I'm in the process of getting a green card. If you have the advance parole, you will be allowed back into the United States, but you need the vaccine to get a green card unless you're going to do a waiver. Let's go to Sophia Henderson. Uncle Brad asking for a friend. Her middle name is missing from her son's birth certificate. Will that delay her petition? Probably not. Let's go to Orlando. Hey, Brad, I'm separated from my wife. I have a 10-year green card. Will I lose my green card if I travel out of the state and come back? No. As long as you have a 10-year green card, you can travel wherever you want. You don't need to live with your wife anymore. Let's see what else we have here. Slade Bryan. I'm a green card holder. I have a minor child who overstayed their visa. They have no social security number. How can I claim for them on my taxes? You can't. Ola Aid. Hi, submit I-130 in 2020 and awaiting approval. I lost my H-1B. My spouse will naturalize in 2 weeks. Is there going to be an issue because I was out of status for a month and a few weeks? No. If your spouse is a U.S. citizen, you made a legal entry into the United States, even if you were undocumented, even if you worked undocumented, whether it's for 1 day, 1 year, 10 years, 1 million years, you can adjust your status. Anton, Pat. I came to the USA in 2012, and I filed a case for I-45 myself, and case was denied in 2016. It was not appealed. Now I am overstaying. Can I refile or reopen a case with new evidence? You may not be able to reopen that old case, but maybe you can start a new case. Fiona Thompson. Hi, Brad. How long is the process time for SIJ after biometrics? Applied for work permit 2. Special immigrant juvenile adjustments take about 1 year, start to finish. The dream. Living it. Uncle Brad, I expedited my EAD for VAWA. I did biometrics, and my EAD shows information requested received 3 days ago. Based on this experience, how much longer could I hear something? Probably very few cases get expedited. There's so many people applying for expedites. It's rare that they get expedited these days. So you're probably going to be regular processing, and that's going to be at least 6, 7, 8 months. Joyce Henry. Hi, Brad. I got my citizenship through marriage. I'm divorced over 10 years. When I renew my passport, can I use my maiden name? My marriage name is on my naturalization certificate. As long as you have a divorce decree that shows you're allowed to take your maiden name, you absolutely can. Lucy Osini. Hi, Brad. I filed for asylum since 2017. All I got was a work permit. I got married to a U.S. citizen. I suffer abuse. I filed for VAWA. I've got my prima facie. If I cancel my asylum case, can I still go to my country? No. You filed for asylum. You said you were fearful of going to your country. Now that you're getting a green card some other way, now it's safe to go to your country? You know what immigration is going to say? Huh? Kiasa. Squad up. In my country, adoption is not allowed. We have something similar called kafala, which is the legal custody. I'm filing an I-130 for my child and asking for proof of adoption decree. What should I do? Well, if there's no adoption, then it's not your child. Then it's a kafala, legal custody. And there's no legal custody filing in the U.S. That's not your child. You can't file for him or her. Kimberly Powell. Hey, Brad, what if your police record expired while awaiting the interview date for an immigrant visa, person over 21 years old? Then you would need to do a new one. Subuntu. I came to the U.S. through a spouse visa in 2018 and got conditional green card. I applied for permanent green card and couldn't reapply for 2 more years. In the meantime, I got 1 child, but I'm not currently living with my spouse anymore. Can I file this year a tax return alone? When should I apply for citizenship? I came to the United States through a spouse visa in 2018 and got conditional green card. I applied for permanent resident card, and it took over 2 years. In the meantime, I got 1 child, but I'm not currently living with my spouse anymore. 2023, 5 years after you got your conditional green card in 2018. So it depends on what month you got your green card in 2018, but it's basically on the 5-year mark. Go Gabalisk Sumo. All you see is the top of my head. I'll give you my eyes. Hello, Brad. I'm Anthony Flomo from Indianapolis, Indiana. I started talking to a girl on Facebook in the 2nd week of February this year, and I traveled to Africa at the end of the month to visit my family. I was there for 3 weeks. I was able to meet this girl and spend time with her and got to know her a little. I came back the 19th of March, and since then, we've constantly communicated. I am in love and with her already. My question is, if I file for it now, will the application have a chance? A fiance visa? Absolutely. You're in love. You met. File a fiance visa. Christopher Kane, is it true that green card holders can't file for children again? That is absolutely not true, Christopher. Unclubbins official. How long did case take after transfer to NBC? I don't know what you're talking about, what the case is. So until I know what the case is, I don't know. I need to know a lot more. Ola, aid. I submitted the I-130 in 2020 and waited approval. Oh, I asked that one already. Hi, Uncle Brad. Double checking. Can someone file for a visitor's visa while waiting for an interview for their I-130? You can, but I doubt it would get approved. Alaji, so, hi, Brad. I got my prima facie after 5 months of filing a VAWA. How long does it take to get my work permit? You won't get a work permit unless you filed an adjustment application. It'll be 9 months after you file your adjustment. Hamida, what is the processing time for an I-130 immediate relative like a child? Over a year to get an I-130 approved. Sean Bryan, hi, Uncle Brad. I had my interview for adjustment of status on January 2023. And as of then, we have not had our 2022 income tax filed. While the case is under review, can I turn in the 22 tax to the USCIS? No, do not turn in anything. Only turn it in if they ask. Brandon, from the moment you file your citizenship, how long does it take to become a resident? And what are the steps when you file? From the moment you file your citizenship, it'll take 9 months to become a citizen. I don't know what residence steps you're talking about. Sean Bryan, hi, Uncle Brad. I had my interview for adjustment of status in January 2023. I already asked that question. Mujir Concha, I have a combo card with a pending VAWA and I-45. Can I travel out of the country if I came without inspection? I do not have a criminal record. Yes, you can travel outside with a combo card. Musi Walde, can I get a citizenship with a dismissed misdemeanor? It depends on how long the misdemeanor was. You need 5 years good moral character, even if it was dismissed. Hi, Uncle Brad. I had my interview for adjustment of status. I already asked that question. Karma says, hello, sir. If I was granted asylum in 2019, I applied for my green card in 2020. I got my I-45 approved in 2013. But my green card shows residence since 2023. When can I apply for citizenship? I assume you got your I-45 approved in 2023 too. So that would be 2028, 5 years from when you got your green card. Jiwa Hakim, how long does it take for employment authorization card to come out after fingerprint in New York? 6 months. And Yari Reyes, question, they denied my husband I-45 because of his previous marriage out of the United States. I'm a U.S. citizen, being together 18 years and 2 kids. What is the process of mandamus? What should happen next? You wouldn't file a mandamus if you were denied. We would need to find out the reasons why they were denied, why you were denied. We would do a FOIA first, see what the reasons were, and see if we can overcome it and refile again. That would be the process. Kenneth, afternoon, Brad. I have 2 of my kids in Sugar Land, Texas. I went to my home country. We have our marriage license while I'm here in my home country. My kids were taken by CPS when their mom was found drunk. I don't know what the question is. I'm sorry that Child Protective Services took your child. Silas, hi, Brad. How long does it take to get a green card if you're brother of a U.S. citizen? About 15 years. All right, we're gonna do one or two more. Lanray Lowell, hey, Brad. What's the process for moving from F2A to IR1 if I-130 is pending approval? The petitioner submits the copy of the naturalization certificate and requests the upgrade. And last question for social media check-in. Good evening, Brad. Is it true that if you overstay your visa for 7 years, then get married, you can put in your paperwork in? Yes. If you marry a U.S. citizen, you overstayed for 7 years, you can put your paperwork in the next day. As long as it is a bona fide marriage, you will get a work permit, travel document, and ultimately, you will get your green card. All right, so that is our social media check-in for April 3rd, 2023. I want to introduce you to Tony Peralta now. Tony Peralta is a first-generation Dominican American contemporary artist and graphic designer. We visited him at his studio in Uptown Manhattan and spoke to him about Peralta Project, urban lifestyle brand, and how his parents' immigration story has affected his career and how it's reflected in his work. Let's watch.
What's good, Brad Squad? It's your boy, Jonathan Elias, and today I'll be talking to the great Tony Peralta at his own shop, Taller Peralta in Uptown Manhattan. You guys might remember when I spoke to him at Citi Field for the Dominican Heritage Night, but today we're getting up close and personal with him, all right? So we're gonna check out some of his signature work, his hats, t-shirts, sweatshirts, paintings, and much more. We're also going to talk to him about his family's immigration story and what it's like to keep the Dominican and New York culture alive through his artwork. Let's go talk to him.
Mr. Tony, what's up, man?
What's up? How's it going?
Hey, it's good to see you again.
Likewise.
First of all, your shop is dope as heck.
Thank you.
Your shirts, your sweaters, your paintings and all that, it's real dope. You're a contemporary artist, right? So what made you even go down this path, and like what made you actually want to be an artist?
I mean, I've been drawing all my life. Drawing, an art is one of those things that it was the only thing I was good at when I was younger. In school, I wasn't always the best student. I figured out later in life that I was a visual learner. Classes like math and science, I didn't really do that well. I was always in an art program from elementary school to high school. After I graduated from college, I wanted to be a filmmaker. I couldn't find a PA job at that time. So after a year of trying to get that kind of work, I got this opportunity to work for this PR marketing company that worked with urban brands.
Wow.
So 1999, 2000 at the height of like FUBU, academics.
Definitely used to wear all of those.
All of that, you know what I'm saying? Like Sean John, 555 Soul. I got better as a graphic designer, and then being around all these brands, with hip hop and growing up in hip hop, has always been about hip hop and fashion. So I was like, I want to do this. And a few years later, I started a brand called the Peralta Project. Throughout the years, it just kind of starts to take off a lot more.
You're Dominican.
Yes.
All basically of your stuff has like the hip hop, urban type of feel. So how did you put those two together?
I do what I know. It's very simple. I was born in New York City. Both of my parents are Dominican. I grew up in Dominican culture as well as hip hop simultaneously. I grew up in the 80s, so besides my parents being new immigrants, there was also like the birth of hip hop happening. And hip hop was happening as I stepped outside. Like you step outside, you see the b-boys, you see the graph. The stuff that you see visually, you don't really see here anymore. I will go outside and I'll see like graph on the walls by graffiti crews. This was happening in Washington Heights. My memories are what inspires me. People a lot of times they ask me where your inspiration comes from, and it's just like, it's me thinking back at that time.
You just recently went back to DR.
Yeah.
For an amazing reason.
I went for the opening of this design biennial that I'm part of. It's in the Cultural Center of Spain, and it's in the capital in Santo Domingo. I was asked to be part of it, and it was great. It's an honor to be able to go and showcase my work, in my parents' homeland. Right. So that felt really great.
To some people, it might not be that big of a deal, but like to go back to your hometown, your homeland, and to show them like, look, this is what we're doing in the States.
For sure, because it's an opportunity for them to see what being a Dominican American looks like and how I interpret being Dominican.
Right.
So that was really cool. The exhibit dealt with designers, from like clothing designers and people who make like products and even architects.
Oh, wow.
So, I was in really good company.
I do want to talk about your immigration story and how your parents came here, why they came here, when they did.
My parents met here. They both grew up poor. But it's interesting because even though they were poor, they owned the land.
My grandmother had no education. Yeah. She had 6 kids, one on the way. They had land, so she just rented it out. So it wasn't like they were rich, but land is...
It's very important.
Yeah.
My mother was already married at that time, and you get married and you go live with the husband's family. They were so poor that her mother had to come and bring her food. Eventually, my mom, she asked her father for permission if she could leave to Puerto Rico to come to the United States. My father grew up really poor in this little small house with I think it was like 6 brothers and sisters. They all came here to find a better life.
So how does that make you feel to not only represent for your culture, but to actually make them happy and to show them all the sacrifice that they made to come to the States? Was,
I mean, it makes me feel good. I realized that later on. I started to really make sense of like my parents and the sacrifices that they made coming here. But not only that, but just the risks.
Yeah.
And it's interesting because when you grew up in an immigrant culture, your family here in the United States, they teach you not to take risks. It's like, no, you got to get a job, and it's like, and you should be happy and grateful for it and all that stuff. But then it's just like, but y'all came here without speaking the language, not knowing anybody. I feel like now being an entrepreneur, I'm honoring them by taking the risk of opening up a shop and doing the stuff that I do. My mom has always been proud of like what I did. All she told me is like, yo, you gotta work or go to school. My father, you know, owned a grocery store here.
Wow.
Yeah. So they both have that entrepreneurial spirit.
You opening your shop here, because I'm sure you could have opened it anywhere. What made you open it here, and how has that helped you still being in touch with the deep culture?
I never thought I was gonna be able to open up a shop here.
Wow.
Because you know we're in the process of gentrification.
Yeah.
The real estate up here is pretty expensive. I was actually planning on moving to the West Coast. Saw this space, looked into how much the rent was, and you know I was like, okay, I think I could afford that. And it's been great, man. It's been a game changer.
That's
for me.
amazing.
Yeah, it's been a game changer. Yeah.
On that. Do you feel like, you know, because your family moved out here for you and your future, do you feel like because of that you're living your American dream?
I'm living my dream.
Yeah.
You know what I'm saying? It's the dream of being creative and being able to make a living off of that. You know, and I'm just very grateful that I'm able to do this every day. I get messaged all the time about being an inspiration.
You are amazing. Thank you so much, man.
Oh, you're welcome.
Amazing.
Man. Thank you.
So you know I'm about to cop some stuff.
I know that.
All right.
Well, there you guys have it. We got up close and personal with the great Tony Peralta. We got to see some of his artwork, but then also listen to his story, which is so inspirational. You guys definitely have to come up here and cop some of his stuff, all right? Peace.
All right, thank you very much, Yo-Yo. And that was a cool piece on Tony Peralta. I liked his art very much. I think we're ready for a speed round. I'm going to answer 10 last immigration questions right now in under 50 seconds. I have lost the last two, so hopefully I can do it this time. Let's do it. All right, so I'm going to count down, I believe. We're going to do a countdown. What are we going to do here? A count. There we are. All right. Are we ready to go? 5. I hope we're ready. Fingers crossed. 4. Praying. 3. 2. Let's do it. 1. Let's go. Can I apply for a U visa if I'm not in the United States? Yes. Can a U.S. citizen parent file for a child turning 21 in a few months? Yes. OPT submitted March 29. Can I go for premium processing? Not yet. If your green card expires, can you return to your homeland? Yes. Can a green card holder file for their overstayed spouse? Yes. How long after EAD will I get my green card? A few months. Is first offense DUI considered moral turpitude? No. How long after biometrics will I get my work permit? 4 to 6 months. How long for a U.S. citizen to sponsor their parents? At least 2 years. Can a B1, B2 holder apply to school? No, but they can change the status and then apply to school with a change of status. There you have it. I have done it. Woohoo! Finally! With 10 seconds to go. All right, and green card expires. Can you return to your homeland? You could always return. It's just the returning, coming back to the U.S. is the problem. So the answer was yes, you could always go home. And OPT submitted. Can you premium process on March 29th? The premium processing for OPTs are not starting until mid-April, I believe. And there are your speed round questions. And now we're going to get into our comments of the day. Let's see what our comments of the day are. All right, our first comment of the day comes from Elizabeth Francis, Uncle Brad, the man with the plan on all immigration updates. Thank you. Sophia Henderson, second comment of the day. Uncle Brad, I'm happy you are back online. Thank you very much. AD Go. Brad, I love your show. Thank you very much, AD Go. Deanne Reed, good thing Brad is a well-rounded lawyer full of info on nearly any question you ask, not only immigration. Thank you. Mika Hewitt, only Brad can answer your immigration and your tax preparer questions on the same time. Very true. And I believe that is it. Is that it? That is it. All right. So those are our comments of the day. I want to say, everybody, it was great seeing you all again. Have a great evening. I'm going to see you back here next Monday, April 10th, sometime a little after 5 p.m. start time on Facebook and YouTube. Until then, remember to like and subscribe to Brad Show Live on Facebook, on YouTube, on Instagram, TikTok, and Twitter. Brad Show Live across all social media for lots of great content, immigration, personal injury information, and a lot more. Have a great week. It was a lot of fun. We'll see you next week. Thanks for watching. So, Sam, as part of the production, we have to say this disclaimer at the end of the show. Do you mind reading it for me?
Okay, but you know, Brad, I have to do everything around here.
Forget it. I'll do it. The proceeding was information only and not specific legal advice. Consult an attorney about your individual situation. Prior successful results do not guarantee a similar outcome in the future. To make an appointment with the Spar and Bernstein Law Firm, located at 225 Broadway in New York City, call 1-800-529-5465. That's 1-800-529-5465. Easy to remember, 1-800-LAW-LINK. That's 1-800-LAWLINK. Once again, make a call to 1-800-529-5465. And of course, link up with the law offices of Spar and Bernstein, located at 225 Broadway on the 5th floor. If I were you out there, make the call, make the link, make the connection, make it Spar and Bernstein. 1-800-LAWLINK. That's 1-800-529-5465. And visit us now at our Connecticut office, 221 Main Street, Suite 501, Hartford, Connecticut. Visit us in Connecticut or in New York at 225 Broadway. That's 1-800-529-5465. 1-800-LAW-LINK, 1-800-529-5465.